SJC-13151 in the matter of an impounded case.
Attorney Kilkelly.
Thank you, Judge. Good morning, may it please the court. My name is Michael Kilkelly, and I represent the child appellant in this appeal from a CRA where the issue is whether the school district, who is the petitioner, the prosecutor in a CRA case, must be represented by counsel, by an attorney. I would just point out to the court that the CRA law that was enacted in 2012 changed the prior Chins law. The Chins law that was in effect from 1973 to 2012 had called for the petitioner to be a school attendance officer or a school truant officer, as it were. The CRA law provides that the school district is the petitioner, and the school district is what files either the truant CRA or the school offender CRA. So the plain language of the statute now calls for the school district to be the petitioner. The school district is obviously not a person, is not someone that can represent themselves pro se in a case. They are a corporate entity, and I would submit that they need to be represented by counsel as such.
You agree they may file a petition?
I agree that a school official may file the petition, correct. That would be in it, like in any custody matter in the juvenile court or care and protection cases filed by the social worker, but then they're represented by the counsel for the Department of Children and Families. So certainly it can be filed.
What are we to make of the juvenile court standing order that says that the petitioner, which could be the school district, shall be present and may be represented by counsel, not shall be represented by counsel?
I think that that's incorrect. I think that the school district as an entity
Do you think the juvenile court
be
standing?
represented by counsel, and that I think the standing order refers to the physical petitioner school official.
Do
whether
you
they're
think
there
the
in
juvenile
court.
court standing order is wrong?
Yes, Judge, I
Okay.
do. I do, and I think it didn't
It
consider,
should say shall, not may, in your opinion.
say, shall for the school district. That's correct. And I would argue that the nature of the CRA case also argues for the school district to be represented by counsel. As the decision in the Millis case pointed out, the CRA case is where the juvenile court intervenes in the custody arrangements of children who exhibit misbehavior that may eventually lead to delinquent or criminal activity.
But that's the next step, right?
Purpose of the filing, Judge, is that the school district is asking the juvenile court to intervene in the custody arrangement of the child. That's the whole reason.
Well, that's premature, right? It doesn't, we get into custody only in more severe cases. We don't immediately jump into a custody determination, do we?
We certainly, the court, the parties try to everything else that they can think of and have tried before the
But
CRA is
but
filed.
as soon as you get into custody, the parents are going to get lawyers, have a
Correct.
right to a lawyer. The child has a right to a lawyer. So we're not at that stage at this proceeding.
Well, I think we were, once the fact-finding hearing was held, once the matter was adjudicated, once there's no more informal assistance, once there's no more truancy prevention program, we are. The point where the petition is filed is where the school is saying, we've tried everything else, and now we need the juvenile court to look at the custody of this child and whether the custody order needs to be made, whether custody of the child needs to be changed. And the petitioners and the schools have an integral role in that determination. Section 39G provides for the school district to be part of the conference and disposition that is the custody determination that follows the adjudication. The school district provides the truancy information or the school behavior information to the court, And then,
But they don't advocate for the school. First of all, the statute requires them, has the authority for the supervisor of intendants to file the action. And then when this is all being considered, the school is not representing the school. The school is there as a party, not even a party, excuse me, as a participant to try to get out what's the best way to deal with this for the child, not for the school.
I would submit that the school district is a party, that they have brought this child before the court to determine what custody arrangement should be made
Yeah, I agree
regarding
that
the
the
child.
statute requires them to do this by statute. And so they do it by statute. And then when the hearing is taking place, they're not advocating for the school.
I think they are advocating for the school district. They are advocating for what will provide the child to alleviate their truancy. What custody order will enable this child to attend school? They are definitely
They're not there to
advocating.
make sure that there's another desk that's filled. They're there to make sure that things are going to happen that's going to be helpful to get this child in school.
Correct. And that involves the only recourse of the juvenile court in order to do that is to make some kind of custody order. And the school district is prosecuting the case, is advocating the case for what custody order would allow that. and would enable
why
that.
do you
There is
take-
no other
Why do you
prosecutor.
take the position that the school district is an advocate as opposed to an entity that provides factual information upon which the court then needs to act?
Because they are an advocate.
Well, no, I mean, that's just, yeah,
That's
that's not an
my-
answer. That's just,
They-
what is it that the school district does to advocate for a position as opposed to just provide
School
factual information?
the school district is an integral part of the determination as to whether the child.
Well, so
must
is
be
every fact witness.
Correct.
So what is it about what the school district does in these CRAs that transforms them into an advocate in your estimation?
That they have brought the matter, they have filed the petition, they have to prove beyond a reasonable doubt whether the allegations of the petition approved. And then they're required to be part of the conference and disposition where the court determines what custody arrangement needs to be made by the court. So
Does
that
the
the
school
child
district,
will not be truant.
excuse me,
any
counsel,
longer.
does the school district need to prove beyond a reasonable doubt? Or is it what the judge needs to find? Is
It's
that
that-
the burden that the judge needs to
The-
find based on the facts provided by the
Phyllis,
school?
The Millis case says that the party that initiates the CRA proceeding must prove the allegations beyond a reasonable doubt.
Right, and I'm going back to first principles, the statute itself. Does the statute require the petitioner to find beyond a reasonable doubt, or is that just the burden that the judge needs to find at that point? Like that is,
That's the-
I understand Millis says that.
Proof that the court needs to find that needs to be proven by the petitioner.
And where is it say by the petitioner in the statute?
I would have, I believe that section. I'd have to look at the section that provides for the fact-finding hearing. Your Honor, I believe provides that the petition must be proven beyond a reasonable doubt.
By the petitioner is,
Petitioner.
and
It's a
you think if I look at the
petitioner's
statute, I'll find by the petitioner in it? Okay.
Does the principal or whoever shows up for the school have to file a notice of appearance?
burden. No, I don't believe so, but I believe by their filing of the petition, I think that's considered their appearance pro se, but no, they don't file a separate notice of appearance because they're not counsel and they're not.
Your corporate argument is interesting. Have we had any cases that apply it beyond the traditional, corporate entity?
I was not
for-profit?
able to find any, and I don't think the appellee's briefs found any that applied the practice of law to cities or towns or school districts. No, it seems to be an issue of first impression for the Commonwealth. And I would submit that requiring attorneys for school districts will help the judges, will help the courts, and will help children.
Well, the juvenile court doesn't think so because they allow this practice to happen and the rules allow for the petitioners, the districts to represent
I think
themselves.
the juvenile court can be short-sighted sometimes and maybe doesn't want to have counsel in this kind of situation. But what happens
But I think
in situations like this
if-
is that
excuse
the
me,
judge then has to
Ca-
make all the questioning. Sorry.
It might be
Judge.
helpful if you let me ask the question, okay? Just on that same point, because we regulate the practice of law, right? So, and as Justice Kafka alluded to, there's an informality of these, at least in the initial stage, till they get to, DEFCON 2 and the taking away of the kid. Why wouldn't it be in everybody's interest to have, and you practice in this area, so you could tell me, why wouldn't it be in everybody's interest to have a more informal proceeding that's geared towards getting this child back into school and on a better path?
Well, there is the provision for that initially when there's
Oh, no,
informal assistance.
I understand that with the
There's
statute.
other things.
But keep-
But once it gets to a fact-finding hearing, I think the cart has left the barn. That's where things have not worked. The child is in jeopardy of being taken out of the custody of their parent or guardian, put in the custody of DCF.
But how does it help the proceeding to have the school district represented by counsel?
It helps because it alleviates the need for the judge to question witnesses, to gather facts.
But judges do that all the time, right? I mean, trial judges do that all the time where they act as both the fact finder and the decision maker. They have bench trials, they have 258Es, they have 209As. They do this all the time. So why should this be different?
I think they do that in situations where the parties are pro se, not where the
Well,
parties
forget
are.
about the labels of the parties. I'm talking about the responsibilities of the judge. The judge does this, the trial judges do this all the time, where they
Right.
wear both hats.
But not in situations where allegations must be proven beyond a reasonable doubt and where custody of children may be placed in the state, in the Department of Children and Families.
Well, they do this beyond reasonable doubt. They do this, it's section 7 and 8 hearings. And that's the beyond reasonable doubt standard. And the judge does the same thing. They're the finders of fact and they issue the rulings of law as well. So I'm just wanting to, back to Justice Gaziano's point, because what I'm hearing is a form over substance argument from you, in that we want the school as the filing party to be represented, but we're losing the sight of what we're all here doing. That there's a child that's in jeopardy, there's a child that potentially may need help, and whether or not the person that brought the petition is represented or not doesn't get to that central issue. That's the paramount issue. So why is this form over substance issue of a concern?
Well, because of all the judicial administration issues, all of the practice of law issues, all of the issues that school officials are not subject to the rules regarding the practice of law. And I think the Millis case, I think, is the best example of where counsel would be helpful to the court, to the child, in determining And.
But most
whether-
cases aren't Willis. I mean, Willis was really complicated. Does the distinction, you seem to look at the application for assistance as essentially triggering a custody. Am I wrong that you're collapsing these two processes? I mean, assistance is a preliminary step, right? We don't get into custody issues and then don't judge. I mean, again, you're more familiar with sort of how this
Right.
works in practice, but my understanding is a lot of these cases, we're really talking about assistance, how to get the parents, sort of in the right frame of mind of how to fix this. But we're not talking about taking the child away right away in these proceedings. And if we do make that step, then all the lawyers flood into the system right away.
Well, it's true that parents get lawyers once custody is an issue.
Right.
And perhaps that's when school districts should get lawyers as well.
But isn't
I
that
think
what-
they would be helpful at the fact-finding hearing stage.
Well, they may be
for the court.
helpful, but are
And
they,
that's when the court determines
gotta
whether
let
to
us
go
finish.
forward.
but they may be helpful, but helpful is not the issue. The question is, are we really getting into legal distinctions? I understand in Millis, willfully became incredibly complicated, what its meaning. But aren't most of these cases about assistance and a factual issue? You know, the kid's not showing up to school and the number is extreme. We're not really into legal distinctions yet, are we?
Right. I think the cases really come down to whether taking the child away from their parents and putting them in DCF is going to improve the
That's
situation.
but
how
again,
that
you
will
just
be better.
jump to that. Each time you jump to that, is that really how it works? That immediately when you go into one of these proceedings under 39E, that we're really talking about taking custody away from the
The
parents?
child doesn't improve, if the child's truancy behavior doesn't improve, there are thousands of children in the custody of DCF through CRAs that are taken away from their families and placed in group homes, in foster homes, in other situations. And that is what happens if the
And that's happening
threat-
without representation. That's happening without representation for the child or that's
Child has a lawyer.
child
and
has
the
a lawyer,
parents
the
are
parents have
entitled to a lawyer,
lawyers.
But the school districts
So
don't
who's-
have a lawyer.
I see. So this is just the judge moving this along on his
But
own?
The judge,
Taking
the
the
school
children away?
district, the probation officer, the school district usually is the one moving it along.
Yeah.
because the
What about the
truancy hasn't
Department of Children
improved.
and Families? Do they get involved at that point?
They get involved at the point where they're awarded custody. They
Counsel?
may not be
Let me
involved
ask you one
before
more
then.
question before,
Thank you.
okay. So you're arguing that the school should have representation. What is the benefit to your client for the school to have representation? What?
It's for my client, it would enable me to have counsel to negotiate with, to talk to figure out what is going to happen with the child, with the case, with the disposition.
You
to be
can't
able to
talk, you
prepare
can't talk
for
to
the
the person who
the
brought the
assistant-
petition?
Principal is a lot harder to, I mean, the assistant principal has a myriad of responsibilities, only one small part of which is going to court to file a CRA. And then the disposition, I think, is something that counsel who's familiar with the child custody and state child welfare system would be much more able to negotiate and to discuss and to partake of an informed discussion about what custody arrangements would make sense in a particular case, and be able to present that to the court in a way that then the judge doesn't have to do the ferreting out and the prosecuting that an attorney would.
Okay, thank you very much.
Thank you very much.
Okay, Attorney Hodge.
May it please the court. My name is Kay Hodge, and with me is John Simon, and together we represent the Lexington, the School Committee of Lexington, or the Lexington Public Schools. As a practical matter, and I think that the justices have asked questions all around what is the central issue in this case, and it is that a motion to dismiss was denied, and the motion to dismiss sought the dismissal of the case because the assistant principal, the attendance supervisor, who by law is required to maintain the records of the school system regarding a child's attendance, had filed a form with the juvenile court, which the juvenile court had actually prepared, had filled it out to say that the child had been absent. The statutory standard is 8 days in a quarter, 8 unexcused days in a quarter, where in this instance, the particular child had been absent at the time of the filing of the petition, 48 days, and by the time of the hearing, 74 unexcused days. The point is that the state has a great interest in whether or not a child goes to school. We have compulsory attendance laws. The whole system is predicated on figuring out when kids are in school or not in school, and those who are not in school, bringing them to the attention of the parties who might
But
help.
that's the easy part of the case, right? The hard part is, when do we need a lawyer? And when do we not need a lawyer? When is this person doing factual work, which she's qualified for? And when does she start straying into legal territory, which she shouldn't do, right? And there's a little
think that
bit
that's
of.
right. I think that that's right. And I think this court has actually, I mean, obviously under Article 30, it is your judgment that will matter because you were in charge and you supervise the practice of law. But in doing that, you've set out standards, and among the standards include, you will look at issues of custom and practice. And I would just ask this court to consider your previous decision in Furtado versus Furtado, in which a probation officer brought the complaint and actually prosecuted a failure to comply with the support order. And in that case, this court also referred to the rules of criminal procedure, Rule 2B 13, in which you define that a prosecutor can include an individual who is a police prosecutor, a non-lawyer. And I would also then ask you to consider that this particular process, now the CRA process, it used to be CHINS, and it has had a number of different, if you will, iterations. But in the most recent standing order of the juvenile court, that a desire has been expressed by the legislature in the 2012 amendments to the statute that made this a CRA, child requiring assistance. And the court has adopted and enclosed in that. And I think that what's important is in the most recent standing order, the court sort of attempts to balance, the juvenile court attempts to balance the interest in efficient and positive justice at the same time that they also intend to try to consider the legal standard. And I want to respond to, and I don't remember because you're wearing masks, I can't tell who's speaking. In any event, I just want to bring together a number of the strains of discussion that has happened here already this morning. First of all, and this is in the standing order, it is part 7B commentary. And this is just commentary, but this is commentary to the rules of the standing order. Though beyond a reasonable doubt is the burden of proof at the fact hearing, the statute does not require an evidentiary hearing. It is recommended as a best practice that the court conduct an evidentiary hearing and that such hearing allow for the admittance of hearsay evidence. Hearsay is not addressed in the statutes or case law, but due to the flexible nature of these proceedings, it is recommended that reliable hearsay may be admitted. Now,
along the lines of that, and going back to Justice Weddenland's point, the statute 11939G, it doesn't require the truant supervisor to prove the matter beyond a reasonable doubt. As Justice
No, it requires
Wendland
the
was
court.
suggesting, if the court finds the statements in the application for assistance have been proven at the time of the hearing beyond a reasonable doubt. And so that seems to merge with what you just said, about the standing order as well.
Yes, Your Honor. And I think that basically, if you look at all of the pieces, the issue before you is whether or not this particular assistant principal, who is the attendance supervisor, who is statutorily assigned responsibility for keeping attendance and for acting, frankly, while I always say the corporation is a piece of paper. It's not, it has to act through the people who are there. In this case, it's the attendance officer who filed the particular application for a CRA. All she is doing, and we would take the position, and I do in my brief, that she was not, in fact, engaged in the practice of law. Because remember, your case law is clear that it has to be wholly within the practice of law, which I think is important because you've made distinctions in the past of those who are essentially tax preparers versus those who actually go into tax court or into court to argue about issues. So what I
Counsel, can I probe you on that point? So Justice Wendland's point, I don't know if we got an answer to this.
Okay.
So the superintendent who's in charge of keeping these records
Yes.
sees that it exceeds the amount that a student can be truant and files this.
Mhm.
And then they go to the hearing and then they act as precipient witnesses and they tell the judge, here's what the records tell you.
Mhm.
At any point after that, does that person advocate for a particular outcome?
Not that I know of, and certainly not in this case, because if you have the entire transcript, it's in the supplemental record that was provided by Lexington. And frankly, there was at no time, there was discussion of custody, but the fact of the matter is all that the assistant principal did was to provide necessary facts of the steps that had been taken by the school system to attempt to get the child to attend school. Now, the point I think that's really important is it is the state's interest in getting the child to attend school. From the point of view of the school, whoever has custody, the child's going to be at that school. It doesn't really have an interest, I don't believe, nor was there any evidence in this case that it had an interest between whether it was the father or the mother. It was just they wanted the child to come to school because that's the interest of the school system.
That seems really important. That seems really important. It seems what you're saying is that the school at the hearing is not advocating for the school.
Exactly. They don't have an advocacy position. They have a clear role. What is their role? It is to provide factual information about the attendance. Obviously, that's the triggering event, but also what else has been going on around the child, which includes in this case, the various efforts to meet with the parents and to meet with the mom, meet with the father. They were not together, and otherwise to get other services to this particular child. But at the end of the day, from the school system's perspective, regardless of who has custody, I'm not sure that there is, in fact, a particular issue that the school has an advocacy position for. And indeed, they have to work. Remember, the school has to work with whoever gets custody to make sure that this child is educated.
But before you go, could you please answer the corporate form issue?
Your Honor, it's very clear, at least from the case law that I found. And that is that this court has always made a distinction between private moneyed, the word moneyed corporations versus public entities, which are there for the public political purposes. And we even call cities and towns, political entities. And therefore, that's the distinction. And the court has repeatedly said that the rules regarding corporations are inapplicable when it comes to a public entity, even though as a corporate matter, we use the word corporate little c as opposed to corporation. And in my brief, I list each of the cases that was cited by the appellant and show that those are all dealing with commercial events. And certainly not with the kind of event that's essential here, which is the state's interest in compulsory education and in a student getting educated.
But if a municipality or school district has, an interest and advocacy, not outside of the CRA, right? They would be a capital C corporation, right? You would need to have counsel representing the interests of the school district in, say, a discrimination case.
Oh, absolutely.
Okay.
Oh, no, I'm not suggesting the absolute, but in this instance, I think their role is a factual role. And I think that the process, if you look at the standing order, it is very clear. There is a preliminary hearing, and the rules require that the judge hearing, the preliminary hearing shall not be the judge hearing the fact-finding conference. Then you move on to a fact-finding process, and that moves on then to conciliation, which then moves on to yet another phase, which is the custody pieces, where there are in fact lawyers. And I would defer, quite frankly, to others counsel and or I would say appellant's counsel on the intricacies of that process. But I will say on the issue, which was the basis of this decision, which is whether or not Lexington Public Schools engaged in the unauthorized practice of law, I would urge this court to find that it did not, so that we can continue a process that has existed for decades and decades. And Millis is inapplicable. In that case, it says very distinctly that the school system played no role in the appeal of that case. It had no position on whether or not something was or was not willful. It did not proceed in the appeal.
Okay,
If
thank you.
there are no further questions, I rest on my brief. Thank you very much.
Thanks. Okay, Attorney Remillard.
Good morning. May it please the court. My name is Maria Remillard, and I represent the mother in this matter. Requiring an attorney to represent a school district or a supervisor of attendance in CRA actions would fundamentally alter the nature of these proceedings. It would create a dynamic where everyone except the parents would have counsel from the commencement of the case. That result is untenable, given the parents' right to counsel only arises when custody becomes an issue. These CRA proceedings are meant to be relatively informal. The thrust of the entirety of the CRA statutory provisions is to move many of these issues not into the courtroom, but outside of the courtroom. And that's demonstrated by the statutory language where the clerk is required to give materials to the petitioner. If you look at the petition itself, there needs to be an affirmation or a statement as far as what services were provided to the child to avoid court. The purpose of this statutory scheme is to guide children to rectify their behavior. These CRA proceedings functions more like a social service function as opposed to an adversarial litigation proceeding where hearsay is allowed, and these hearings tend to proceed very similarly to what is in the transcript that was provided to this court. The judge conducts the hearing with very open-ended questions, and that's not dissimilar to what a judge typically does in many other matters. Such as here, the judge asked why the petition was brought, what the petitioner's duties were. He was eliciting information and directing how the evidence would come in. And certainly the petitioner here functioned in cases in general, the petition functions more as a reporter of the information, a reporter of the days missed, reporter of what actions have been done. This is what transpires in the thousands of cases that are brought before the juvenile court. Requiring school districts.
What do we make of the language in Millis that says that the petitioner has the burden of proof to show beyond a reasonable doubt?
The statute doesn't say the petitioner has the obligation. In fact, under the statute, there's no mention of petition. And if we're looking at the statutory language, which we must, by putting in the petitioner there, we're adding language to a statute where the legislature certainly could have done, but they I would submit to the court, chose not to do because of the function of these kinds of proceedings, the nature of the proceedings. Mother would advocate that requiring counsel for the school district or supervisors of attendance at the initiation of these kinds of proceedings would adversely affect the rights of parents and certainly create this untenable imbalance where the school district would have, and the supervisor of attendance would have an attorney. The child is entitled to an attorney from the commencement of the proceedings, yet the parents don't get counsel until custody becomes an issue. And as you saw in the transcript, at that time when custody is being addressed, sometimes the judges have definite opinions as far as the involvement of the parents and their behaviors.
I have a question of what happens when the school person is sort of being asked to interpret the law. The judge apparently expressly invites Ms. Barry Neg to respond to the question about unauthorized practice of law. She has no idea about that, right? She shouldn't be doing that, right? And isn't that why we don't want them doing certain things?
I don't see her role in her response as any different than a pro se litigant, because under the statute.
But you say she's not litigating. She's there as a fact person. Shouldn't we at a minimum provide guidance that says, okay, you're there for that purpose. You're not there to, I mean, I'm just interpreting what she says. Mass general laws actually does allow me to file. It does not say attorney or counsel, almost implying that the legislature, when they created the law, knew that requiring an attorney for every CRA would almost deter us from filing them and helping children. She may be right, but she's not a lawyer. She doesn't know anything about legislative history, right?
She's not a lawyer, but she is someone authorized under statute to bring this action. And it expressly states that a supervisor of attendance may bring an action under 39E, which is what she did. And the
I
terms
agree
of,
she's there because she knows about school attendance and she can bring in the records, but she really shouldn't be opining on legal issues. If they need to opine on legal issues, don't we need a lawyer?
there are pro se's who represent themselves, who are able to give legal arguments. Now, certainly if this was an individual who was not a supervisor of attendance, I would certainly concede that there would be a requirement that there be representation for those types of legal arguments. But here, in the facts of this case, we have a supervisor of attendance who's expressly authorized.
So if the judge goes to her, was this willful or not? Is that also something? I mean, we've made willful into something pretty complicated. And I understand Ms. Hodge's point that the school district wasn't in that part of the case, but do we want them in that part of the case, defining whether someone's willful or not?
I would submit that as parents would likely not want the school committee to do that, but the willful part is part of the fact finding. Because when you look at the Millis Public Schools, the issue was at the fact finding hearing, as here, a judge had to find that there were these absences and that it be willful. And it needed to be
So are
beyond.
they starting to practice law when they start going beyond saying, okay, you've been gone 9 days or you've been gone 24 days, but based on what Millis says, you're willfully gone 24 days.
I think that the willful is an application is getting the facts and the judge's application of the facts to determine whether or not it's willful. Because in Millis, there was facts that were presented with respect to the child's substantial health issues. And the reasons why those health issues impeded her ability to attend school. So it's the judge's application of the facts to the willful standard that was promulgated in Millis. I see my time is up. If the court has no further questions, I would rest on my brief. Thank you.